Thanks so much for attending. We're live from Las Vegas and we'll get right into it. We came up with this seminar because many times we find over the years, I've been practicing for 33 years, that the aspect of planning associated with the sale of your business is completely missed. It's very significant because of the indemnity and exposure associated with your sale. The idea is to limit the indemnity exposure in the documents themselves, obviously, in terms of the corporate work, but also through asset protection planning. And what we're going to work through today is some limitations, some structuring, and some traditional planning that we can get involved with, which will limit the ability of a buyer to make a viable indemnity claim. That's the general idea. This is the agenda. We'll first go through where the exposure associated with selling the business comes from, the indemnity provisions. Then we'll go through some of the overview ideas of asset protection. And then we'll look at a little detail associated with piercing the corporate veil, LLCs, and trusts. On the sales side, the idea is that someone intends to buy your company. They're either going to buy the assets or they're going to buy the stock with the assets inside the entity. And when you sell the entity, you're going to make certain promises as the seller, or we have a lot of CPAs on the line, I understand. Your client's going to make a tremendous amount of warranties and representations such that the buyer receives reassurances as to the status of the business. Those include these that I list here. Taxes are paid, the entity's in good standing, properly capitalized, you don't have any existing litigation, this type of thing. One of the key and fundamental representations that really draws the most negotiation are the financial representations. In other words, several years' financial statements, depending on the type of transaction, will be attached to the document, and the seller individually, or the partners individually, will represent that they're accurate, will represent that there's no aspect of them that could be misleading. Of course, the way the negotiation works is maybe the seller didn't have a full audit, or maybe the seller is preparing financial statements in-house according to their format or their tax format. And the representations start to move into, well, now we need an audit, or you're going to have to represent that if you had an audit, your financials would look like X or Y. And you start to lose a little track associated with your exposure. A lot of times you can welcome an audit when it's not practical. What happens is we want to limit the financial liability to a certain number, for instance, and let the buyer review everything and take as close to as is as possible. It's a negotiation. The seminar, this particular webinar, is not about how do we negotiate a corporate deal, but we're trying to give you a flavor for the overhang and liability associated with closing. And the financial side is very instrumental in light of the fact that if in fact it's not done properly, and for instance, the buyer mismanages the financial aspect of the business, well, the buyer is going to want, even though it may be their fault or partially their fault, is going to want compensation. Well, wait a minute, the business isn't worth what I paid for. You said this, I asked for Y, you gave me X. And then you get into this exposure. That's very common. I wouldn't say very common in terms of overall transactions, but it's in terms of when you have claims and problems, that's a big one. Other warranties and representations involve are contracts that are important to the business in good standing. Have you had problems with these suppliers or these clients, etc.? Do you have, like I had mentioned, employees that are in litigation, or have you been sued? Are you really operating according to the rules and regulations governing your business? Here's some more which are usually less significant, like environmental, depending, of course, on the business. Are the assets that are being sold necessary to run the business? This type of thing. Are you going to be making any tax representations? Are you changing form? Is the buyer purchasing your stock but treating it like an asset deal so they can also depreciate the assets being acquired? Are you representing that it's okay, or is that their problem? Are you telling them, hey, these financials, this is the investment intent representation. Are you, hey, these financials are correct, but look, we don't know what's going to happen in the future. You're taking the risk. These, this is how the negotiation of an M&A transaction goes. It's what I did the first 10 years of practice before I got into the planning and all the estate work. This is more the same on the warranties and representations. Unlimiting indemnity provisions, we create a deductible. In other words, listen, don't bother us as the seller until you've got claims exceeding, let's say, $500,000. Otherwise, you get this nickel and dime. We had a problem here. You didn't tell us about that. She didn't show up to work. And so you have a deductible. And the deductible can be a spillover deductible, which means that once you have problems and those problems amount to the 500 or the 100,000, then you owe the 100,000 plus all the other damages. And then you have a maximum indemnity. Of course, the maximum should never exceed the purchase price. I've actually seen people sign where it didn't, but you can reduce it further. We have had significant success with reducing the maximum indemnity to some fraction of the purchase price, depending on the negotiation leverage, let's say. A lot of times we can reduce the exposure through escrow. In other words, we can say, okay, look, we're going to put some money aside. It's $100 million. We're going to put 2 million aside, but we don't want a large indemnity. And a lot of times that money in hand will be very attractive to a buyer. Not listed here also, occasionally we can get insurance, believe it or not. You can buy insurance to cover warranties and representations. When that first came out, it was very popular and very affordable. It's become more limited and less affordable, the warranties and representation insurance. And then you have this exclusive issue, which we see pop up its head with people who don't know how to do these sales transactions, where we had a seller sign an indemnity. This is what I owe if my warranties and representations are incorrect, but it's not exclusive. Can you imagine that? Imagine you have this indemnity, you pay the indemnity, and they sue you on something else because the indemnity doesn't cover your exposure exclusively. It happens. So that's the exposure side. We then get into, okay, if we can, long before we have a deal or a closing, at least in that letter of intent, or we go into the process, we do some protection, right? We do some LLC, some trust, some exempt asset protection, such that down the road, if there's an indemnity claim we had absolutely no idea would occur, really not related to the current thought process and unrelated to estate planning, which we would utilize as part of the planning. You want to get as far away from the closing as you can. I'll explain that to you why. This is just a general asset protection overview. And the idea is you get into this as far or as early as possible, such that you can utilize the four aspects of asset protection, being titling. And what we mean by titling, for instance, I'm from Florida, I'm in Las Vegas now, but Both jurisdictions allow certain tenancy by the entirety, which means husband and wife can own. That's the title to the property. In other words, if in fact you have this tenancy by the entirety and one spouse is sued, a claim is made against one spouse, the property is not available. If it's funded properly and it's tenancy by the entirety, you have to have a claim against both spouses. It's interesting to see sometimes when we represent a seller, we usually represent the seller in the transaction, not a hedge fund, where we'll go through a whole transaction process, which could take between 60 and 120 days. And the team, the legal team on the buyer side has no idea about title. They have no idea about asset protection. And it's fascinating to us because we'll be in a meeting with the client and then pop on a meeting with the whole group, including the buyer. And we'll have gone through the idea that in the document, in the sale document, the buyer's asking for all these protections, but the spouse isn't signing the document, which is absolutely nuts. So you can do tenancy by the entirety planning if the spouse doesn't sign the document. Those assets titled tenancy by the entirety aren't available. And it just happens all the time. The same is true for exempt assets. In other words, different states exempt certain assets, and the exemptions really vary from state to state. That would be like life insurance, your homestead, annuities, deferred compensation accounts, like a 401k. A lot of times these assets are exempt, or partially or totally. In Florida, mostly totally exempt. In that you don't need an entity, you don't need titling, you don't need anything. And if you're sued, for instance, that indemnity hits, you have a huge deferred compensation plan. It's not available to anyone, to any creditor. Trusts are traditionally a gift to someone else. And the reason I wanted to include a trust discussion is because we're in Nevada. And trust basically required until about 1980, since about 1480, 1500, that dad, mom gives to brother in trust for child. And what that did was that divided title. I give in trust for someone else, but a third person has legal title. Very interesting, isn't it? So titles divided. The trustee receives the gift, has legal title, but cannot benefit from it. The beneficiary does not have legal title, but is the only person who can benefit from the asset as long as the trustee says so. It's 500 years old and it's still among the best asset protection vehicle. What happened in Nevada and Alaska and Delaware is statutes were created whereby you don't have to give it to somebody else. You can benefit from your own trust, and we'll get a little deeper into that. And given the right circumstance, it's really a very powerful vehicle. And then, of course, we have LLCs. LLCs are interesting because we can hold them by the entirety, is number one, which requires a suit against both husband and wife. And then LLCs, unlike corporations, if you sue someone that have stock in a corporation, the corporate stock is completely exposed. With LLCs, the general rule is that if someone sues an LLC owner, in other words, an indemnity claim hits, the seller is sued, the seller has a family LLC, the seller only has a lien right against that equity. Only a lien right, cannot take the equity. That's a general rule. So what we do is we take all of these tools, the entities, the trust, the titling, right? And the exempt assets, and we combine them into a plan for each client. And that plan usually involves a family entity that's held by the entireties, trust for the kids, and maybe a trust that we create for ourselves. In other words, we have several business salespeople, sellers, clients who have created a trust for themselves because there is no tenancy by the entireties. They're single, they're divorced or whatever. They're single. And so what we can do is put a trust that we create ourselves for ourselves in Nevada or South Dakota, a state that allows for that, over the LLC. And now, like tenancy by the entireties, where one of the tenants gets sued, but they can't lien the LLC, we put a trust over a single person's LLC so that that equity cannot be liened. These are general ideas. There's detail, and each idea in terms of the self-settled trust, the LLCs, the general trust, the equity, the entities. These are all separate seminars, but we want to give people a flavor for the idea that when we sell a business, we're going to have this open exposure. We want to start planning as early as we can, and we want to create a structure. And we want those sale proceeds to flow into that structure, usually, depending on the circumstances, when and how we're going to do it, in kind of the same lockstep order that we protected all the other assets, and that if anything occurs, the proceeds are protected. I wanted to spend a few minutes on veil piercing. Veil piercing is the idea of having an LLC or a corporation. Something goes wrong in the entity, inside the entity, not someone trying to take your equity in from the outside, inside the entity. Someone falls down, for instance, in a supermarket. That's the classic. There's an accounts payable in an entity. They owe the money. Well, the owner doesn't owe the money. That's inside asset protection. Corporations, LLCs. You operate a business, you basically don't owe anything that the business owes unless you sign for it and guarantee it. But sometimes someone inside the business can pierce the veil out and get to the owner. That's what veil piercing is. I wanted to mention it because it comes up somewhat when we go ahead and look at these corporations and LLCs when we're going to sell them, to see what exposures are out there and what we have to promise. The idea, as Florida as an example, is very strong. It's very, very strong, such that if we have an entity, we're not personally liable. That's been the rule for 30 or 40 years. That's the highlight case. And then we go into elements, and those elements require essentially absolute control over the entity, and that the entity was used for an improper purpose. It's not that clear what the improper purpose it was, but it's essentially you used a corporation to defraud people. Let's call it that. And that fraud or that action, that improper purpose caused damages. And there's a line of cases now which are very interesting, this Molinos line of cases. Because what had happened for years was the idea that, and this comes up all the time, I'm sure even people, especially the CPAs on the line, have come across this issue. We have a company, we're not doing very well. We have some real creditors. We have what we look like are going to be some creditors, and we start making distributions out of the company. Well, that's going to raise an issue. The issue is that could be a fraudulent transfer, right? Fraudulent transfer means I'm moving something to avoid a creditor. And that allows the creditor to go get it. Like if someone sues me, I give my car to my cousin. Well, the person suing me can go get the car from my cousin. Everyone loves that cousin one. I don't know why. Anyway, that's fraudulent transfer. I intentionally tried to avoid someone, or I got rid of everything. I became insolvent. This is not a fraudulent transfer webinar, but to give you an idea, that's generally how it works. The problem with the fraudulent transfer from the litigation standpoint is that there's no damages. You can just go get the car from my cousin, and that's it. You can't sue me for anything else. What these line of cases, though, in Florida are saying that if you control an entity and you use it for fraud and you decide to dissolve and steal all the money out of there, that was a fraudulent transfer case, yes. But now we think you've used the entity improperly. So now not only can we go get the money from whoever has the money, that'd be the owner generally, no matter what they did with it, by the way. We can sue you for damages. If you caused us harm, now all of everything starts to multiply, all the costs and everything. Now the litigation people are interested. That's the situation in Florida. But you have to be in a situation if you're worried about exposure, not only do you control, but you've used the company for an improper purpose, which is pretty hard to prove. That's veil piercing, kind of 101. Of course, we have exceptions. I mean, lawyers and architects and doctors are all liable for their professional acts, not for their accounting, but for their professional acts. And there's certain super creditors like the IRS that can sometimes reach people, even though you may have like a withholding liability, this type of thing. And that's what I have here. By the way, we can send you a copy of the PowerPoint just at the end of the presentation, there's a contact email and a phone number. And like I said, how to avoid this piercing the veil issue, avoid exposure, just run the company. Don't do any hocus pocus. If you run into trouble, you can stop funding the company, but you cannot liquidate assets out and sell them and keep them for your benefit. And then we get into some of the classic ideas of asset protection, right? So we're thinking maybe we're going to sell the business, we're going to set up some structures, and we're going to start to protect what we have with an eye on the idea that we may have some payments. We may get some big payments. We may get a lot of little payments, but we're going to protect that money because if, in fact, an indemnity claim comes up, we don't want it to ruin us. So we can work through LLCs. I had mentioned LLCs were kind of an idea where not only that inside asset protection we have where you're not liable for what happens in the business as the owner unless you have a strange piercing the veil claim. Also, what the LLC offers is if someone sues the owner, they can't get into the assets. Whereas with a corporation, you can grab the stock and take the assets. That's the big issue that's the big difference between LLCs and corporations. LLCs are also much more convenient. There's no annual minutes, this type of thing. You have to be careful with this convenience, though. You make your own rules with the LLC and the operating agreement. And I got to tell you, about half the litigation I see coming in on the commercial side is people just taking an operating agreement off the internet. And there's your traditional veil piercing inside. Now the LLC offers the outside protection. The origins of the LLC were these LLPs and LPs. The idea was if someone sues a partner, the other partners don't suffer. The problem with partnership is like in a general partner, if you have a liability in the business, you're liable. So like no one has a partnership, a general partnership, or should have a general partnership. We had limited partners where the limited partners are not liable, but the GPs are liable, so you have to put an entity in between you and that GP interest. All that kind of became irrelevant when we went to LLCs. Where do we do it? Where do we form it? The different states are different. Some adopted the RULCA, the Revised Uniform Limited Liability Company Act, which is pretty bad. The different states offer substantially different protections. For instance, in Florida went through a whole litigation disaster and ended up with the subject was a single member LLC, and the court wanted into that single member LLC and used a bankruptcy case called Albright to get in. And unfortunately, in the ruling was very broad, so it kind of weakened all Florida LLCs, so that to redo the statute. The statute's pretty good, except on single member LLCs. Florida does not protect single member LLCs very well. So we can choose a jurisdiction. Will the law of that jurisdiction apply? In most cases, we'll get into a few cases. We've seen it does apply in many cases. Sometimes it doesn't apply, especially if you're operating the business mostly in another state. We went into fortify. If you have the LLC and you're single, put a trust on top of it. Here are a couple of cases. We had a woman who was involved in fraudulent transfers. She was being sued by Wells Fargo. She shuffled money out. Well, as soon as she shuffled money out, the money was available. In the end, in that case, that Barber case, the court didn't call it a fraudulent transfer case. It took a protective LLC that I had a hand in drafting in Nevis and called it a Florida LLC and cracked it open. I don't really know why or how they did that, the court, but I think it was really more of a fraudulent transfer case. I don't think she was going to get away with that transfer anyway. But if you follow the rules, you get more like the JP Morgan case. You have to be careful when you're in litigation. If you move your litigation into a jurisdiction, in this case, Colorado, that protects that LLC, you're not going to get to the LLC, and that's what they did in JP Morgan. If you have any questions, please let us know. I know I'm going through it fairly quick, but I just want to give you a nice overview. In Bouchel's an interesting case because it's based on the idea that if someone's dragged into court and they have an LLC or a corporation, there was a case called Sargent where they claim that if you sue me in Florida, I move the certificates to the United Arab Emirates, you got to go to the Emirates to get those certificates. You can't get anything from me in Florida. And Bouchel overturned that case. You can actually go to jail for contempt in Florida until you give up those certificates. And these are similar cases where people went to jail where they owed money. You have to be very careful with that. Interestingly, on the foreign trust cases, we're not doing much on foreign trust here, but we do recommend that if you have a very big sale, that you put a portion of the sales proceeds in foreign trust, just as an absolute bomb shelter type thing. But these are foreign trust cases, and the people were in the court in the US and ended up going to jail because they wouldn't give up the money that was offshore that they clearly owed and had gotten into the offshore entity through fraudulent transfer. But most of them kept almost all the money because the court could not operate offshore. It's the power of the foreign trust. If you fund a foreign trust with no problems on a blue sky, it's very hard to reach that money. Arroyos is an interesting case where you had a case in the state of Maine brought to Alabama to collect. Alabama court said this is a Delaware LLC. I'm not touching it. I'm not ruling on Delaware LLC. So what does that? It suggests maybe we should all do Delaware LLCs. Albright's that bankruptcy case where they cracked open the single member LLC, which led to the weaknesses in the single member LLC in several states, should really move to a state where the actual language in the statute, not like Florida, says the LLC equity is protected and it includes a single member. They actually say that. What is a single member? Well, we found out in this Curchi case, it's a California case where a very wealthy guy decided, well, yeah, you sued me, but I'm not going to make any distribution, so you can't get any money. I've got hundreds of millions of dollars. I owe you 5.5. You can't get in. And this Baldwin was in absolute control of the family entity, which had hundreds of millions of dollars in it. And they ruled that in light of the fact that it was really 99 to 1 with the spouse, that they had the right to, it went back down to the trial court, and the trial court could rule that Curchi could crack into that family entity. Interesting, huh? So when we want to create the family grouping, we want to create trust for the kids. And those trusts for the kids would have, I recommend 5%. We want to have a real multi-member situation, not an exposed single member situation. And if we have a single parent, not married couple, we want to put a trust on top of that single parent's LLC interest. This is more on the Curchi case. Very interesting case, actually, because there was no case law at all really in the country, and the case law in California didn't really talk about what they call reverse piercing, which is just taking equity from outside because they only dealt with corporations. There's no reason to have a case. If you have a corporation and you're sued, you lose the stock. And then many other, this is a click case, but many other cases were much more straightforward. People follow the rules. They funded these structures on time, and they're protective. They were rule protective. So I had mentioned adding the kids, create trust for the kids, and putting a trust on top of that LLC interest from a that's owned by a single parent. On the offshore side, I had mentioned, well, when we think we're going to have a large transaction, a lot of these large transactions involve law in a variety of states, a variety of foreign countries. We do a lot of offshore cross-border transactions and a lot of regulations. And the clients are aware of that, and they follow the rules. I often get, well, what if this regulatory agency asserts, or well, I mean, anything can happen. Well, am I liable? Well, if they find some kind of problem or they make an allegation and can somehow prove it, you're gonna have indemnity obligation. So what we like to say, especially when it's a larger transaction, is why don't we take a portion of your proceeds? If you got 50 million, why don't we take 5 million? Clients, completely up to the client, and put it into a foreign trust, which is extremely hard to get into. It's got a foreign trustee. We like Switzerland in terms of the jurisdiction where the assets are held, and there's no connection to the US. The trust itself is obviously very protective. It's outrageous protections in these offshore jurisdictions. But I think that the most significant issue is that when a court looks at it, remember, this isn't the case. This is not the indemnity case. This is if the buyer wins a case, says, okay, indemnity is owing, seller, you need to pay off now. There's a judgment against you, right? And so your domestic structure is going to be looked at. We've never had one breached in 33 years. And just in case, we've got an offshore structure which is clean, and it's just extremely, it's very rare that any offshore structure is breached. The cases involve maniacs who are just kind of fraudulently transferring, they're doing whatever kind of criminal activity. We don't get involved in any of that. But that's the cases, and still they have trouble reaching into those offshore trusts. And that's more of what I was saying. Here's the self-settled trust. So you have 20 states now. So if you create your domestic investment family holding company, or you have a big business and you're single and you don't want to involve a spouse, or you don't have a spouse, drop it into a self-settled trust. It can be of any tax format. It can be disregarded. Let's create at least some level of protection just in case you're sued individually. So we like Nevada and South Dakota mostly. What happens is you look at the statute and you want as few exceptions to that protection as possible. And we tend to layer them over the LLC, and it works for business as well. And so I think let's see where we're at. Yeah, we're about 2/3 done. So let's talk about trust. So we talked about this asset protection trust, but let's talk about how it works in general. I had mentioned that the idea of divided title is stronger than LLCs, is stronger than any kind of business entity. When you give to your child and you put the asset with your brother or professional trustee or whatever, if your child is sued, the assets are not available. If your child is sued, the assets are not available. That is defined as a trust fund baby. That's the baby. It's real. So we're talking about asset protection, which is great when we add these to LLCs, but also if you're very wealthy, you should have trust for your children, just in case there's a divorce or a car accident, this type of thing. Because the child has no access, if the trust is written properly, a discretionary trust, no access to the asset, and neither does the plan. Neither does the plan. And of course, the trustee doesn't have access to the benefit either, just in case the trustee is sued. That's obviously very rare. So we divide title, we get it out to the kid. Now, if you want the kid to own an active asset, we don't put it in trust. We have the kid's trust own an LLC. In the LLC, if there's some kind of liability that could stem from that asset, we put it in an LLC to trap that liability under the trust. And if we have a lot of properties, for instance, we divide up the properties into different LLCs. We have series LLCs now, but I'm not sure that's quite as protective. Each time we get a property, we put it in an LLC, each office building in a different LLC. That way, if we have a problem with one, it doesn't bleed to all the other ones. And the actual holding company does nothing. People often tell me, no, I did this and I did a management company. It's the holding company. No, it's not the holding company. Because we don't want to create the liability in the holding company because, uh-oh, that owns everything. And the last thing we want to do is have a creditor there who's looking down at a single member at 25 single member LLCs. We have people come in and talk about revocable trusts versus irrevocable. Revocable trusts are essentially wills. They don't offer any protection. We're talking about irrevocable trusts on the protective side. Revocable trusts should not be called trusts. They should be called fancy wills. They're great and they can become irrevocable upon death, but it's a will until death. So can a will, by the way. Will can create a trust upon death. And then these asset protection trusts with these 20 states, you can create your own trust. You get a trustee in Nevada, in the jurisdiction, and you start to fund that trust. And the statute there in the state that's protecting the trust says if you're sued, that those assets are not available. That's a self-settled asset protection trust. And those are your states. We got about 10 minutes now. The states are very different, by the way. I had mentioned Nevada and South Dakota, but in light of the way the cases are playing out, if in fact you live in one of the states, oftentimes like we've seen on some of these LLC cases, oftentimes you want to use the trust that's in the state of your residence. You see what I mean? So it has to do with the Full Faith and Credit Act. So what happens in the states is we have the U.S. Constitution Full Faith and Credit Act. And people tell me, well, the Full Faith and Credit Act means that if I sue someone in one state, it's the same as me suing them in another state. No, no, it's not. The rules are different. The rules of civil procedure are different. Like somehow all the states have to be the same. That's just not the case. What it means is if I get a judgment in one state, I can sue on that judgment to collect assets in any state, right? So if we don't live in an asset protection state where we have a trust that's a domestic asset protection trust, we have to use another state, and we like Nevada, South Dakota. We use a trustee there wherever we choose, and we like the assets to be there. Sometimes it's inconvenient for the client. They don't want to put the assets there. Sometimes we've had clients buy real estate in those jurisdictions. We like to have a connection there because the cases that have gone badly, mostly bad actors, but the cases that have gone badly suggest there's not quite enough of a connection, and here are the cases that have the minimum context. There's not quite enough of a connection to the jurisdiction for us to enforce it. Now, that's usually come out of bankruptcy. Here's some bankruptcy case. where the standards are different. In bankruptcy, if the court decides that, look, public policy dictates that I'm going to take all your assets, the court's going to take all your assets. Be very, very careful with the bankruptcy filing because what happens is you submit to the court. I often get asked, why do you submit? You submit to the court because you're going to have all your debt wiped away. You're going to be discharged of liabilities. But if you have significant assets, even though you may have some debt, probably not a great idea to go bankrupt. Even though the bankruptcy court is supposed to follow local protections, oftentimes it really doesn't. It really does. And that's one of the reasons we say, okay, for if you're really wealthy, let's take a portion and take it offshore. In Uber, you had a developer in Washington State create an Alaska Asset Protection Trust. He formed the trust, it was fine, but all the assets were in Washington State. He was in Washington State. I think one of the co-trustees was also in Washington State. There wasn't really a connection to Washington State, to Alaska, where the trust was, excuse me. And what did he do? He filed bankruptcy. It wasn't a regular lawsuit from a creditor. That's a much harder claim. He goes bankrupt. They say, okay, we're going to wipe out your debt, but you're in Washington State, and we're going to go ahead and apply the rules of Washington State to your claim. I realize you sold your business, you made a lot of money, you got everything protected, but you decided to go bankrupt, and we're just going to say that violates public policy and we're going to use Washington State. And oh yeah, that's right. Washington State doesn't have an asset protection trust, so you're going to have to give up all your assets. That's exactly how the case went. Morton's is a very interesting case. Uh, this was an Alaska resident that did an Alaska trust, like a homemade kind of trust, but he was there. So that's very, very strong. Like I said, he was actually in the jurisdiction living. It's a kind of a involved case. It involves a divorce and a number of creditors. I actually don't think he'd had to give up. What happened was several years passed after he funded this Alaska Self-Settled Trust. The regular statute in Alaska, I think, is 4 years. In other words, if someone does asset protection planning and you say, no, 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 you were trying to run away from me, you only have a few years to make that claim. After that, you can't get to the asset on a fraudulent transfer claim. Mortensen goes bankrupt though and extends the statute of limitations to 10 years, has to give up his assets. Absolutely nuts. Trustco was the idea of the Trustco case. We've got 5 minutes. The idea of the Trustco case, this was a developer in Florida, used the Delaware structure, actually the asset protection structure for the trusts. And it was a fraudulent transfer claim, which means I'm going to go get that asset from the trust, even because you were moving it to avoid me. This would be one of the factors when you look at the indemnity. But interestingly, the defendant had let the lender know when they were doing their planning. So the statute of limitations immediately started to run, and they didn't bring the case in time. So they kept the assets. These are more cases. We're approaching now. We have 3 or 4 minutes. Some of the jurisdictions require significant detail in affidavits. That's Alaska at the top, that Bertrand case. Erskine is kind of an interesting case as well. You really want to follow the rules. You want to create a trust. You want to treat it like a trust. You want to have a different trustee than yourself. You want that trustee to make decisions. Once you start to move assets in and out, and you kind of are look like you control a trust, it's like a sham. It doesn't exist. Kilger was a case where he had actually funded a Nevada Asset Protection Trust properly with counsel. But he upset a court in California so much that they said no, it's invalid. And they try to crack into the case. He reneged on a settlement. It's one of these outliers, but you have to be careful in litigation. And the last few slides have to do with the integrating the trust and the LLCs. And a lot of this stuff, remember, on when you prep to sell, we want to have it all in place long before funding it, starting to fund it. And then when we have our sale, we use some of the proceeds to fund it. Here we talk about the full faith and credit, where if I have a judgment in one state, I can register in another. But if you have a judgment in one state, can't necessarily register it in Nevis or in the Cook Islands. Very, very protective jurisdictions offshore. Here's an offshore chart we did years ago that shows some of the just wildly protective aspects of those jurisdictions. We use a foreign trustee. There's different requirements in terms of disclosing to the IRS what you've done offshore. When it works, it works. And I had told you with some of these cases, when assets are left in the States and you're a bad actor, they'll grab the assets. But when you push out assets offshore, you basically what even in the cases where they put people in jail, they kept the assets. I think in one of the cases, it actually was a Nevada case. The people were in Nevada with an offshore trust. They did give them a little money just to go away, but they kept most of the money. And that's it. We don't want to treat it as ourself. We want to treat it like we would a corporate entity. It's got its own books. It's got its own powers. It's got its own documents. And this is the brute force where we put someone in jail, but it usually doesn't work. And we want to create the separate aspect of it, where are the assets, where the control, and when we do a domestic asset protection trust, we want to create a connection to the trust. We want to actually have assets in the jurisdiction, a trustee in that jurisdiction. It adds to the strength of it. And if you have any questions, just let us know. Come to the conclusion of the 50 minutes. My information's at the bottom. I've written a book on asset protection and 2 books on international tax. If you'd like a copy, I'm happy to send you a hard copy of the books. Just send me an email or give me a call. I'll be back in Florida in a few days, but I have all access to all my email. And that's the end. Thanks so much for attending.